Three defendants, three very different fates. One walks free on probation, another fights for a second chance, and one hears a sentence that will change his life forever. What happens inside this courtroom will surprise you.
Good morning. Are you Sebastian Sepa?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Sepa, in cause number 25 DCCR 0310, you're charged with the state jail felony offense of theft from a person, and that's from February 5th of 2025. And how do you plead to that charge?
Guilty, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, you go over them with Mr. Lewis.
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Sepa is not competent?
No, Judge, there is to competency, but I was made aware after speaking with his mother that there is some mental health issues where he has not done his medication.
Okay.
So as far as any,
We'll make that part of probation. Okay. Is there any restitution?
Judge, we sent our standard. The short answer is no. So we got our standard restitution letter, and we did not receive a response back.
Okay. Any reason not to waive the pre-sentence report? Do you anticipate that there would be, based on the facts? Let me look at this.
Well, Judge, the allegations are that this defendant was in the process of a theft from a vape store, and in the process he pulled the clerk. Yeah, it's not that egregious.
I'm just saying, but they didn't. Nothing was actually taken, so there wouldn't be restitution. So no reason, no history to speak of that I need to be
just some
concerned about.
juvenile history, Judge. He does have a couple of pending cases in Refugio County, but as far as I know, they haven't been adjudicated.
Okay. And then, Mr. Sepa, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report. I'm going to find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That's going to include following any treatment and recommendations for any type of mental health issues that you have. If that means going to Spinal Tap or a doctor or wherever you live, something similar to that. If they recommend that there's medication you're supposed to be on, then you will be required to take that now as a condition of probation. Follow through with any counseling and all of that so that you'll be successful in probation. Do you understand?
Yes, ma'am.
It looks like it's trying, but it's. I'm going to hand you in just a minute the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will talk to you today before you leave the courtroom and give you some documents so that you know when you're released that to go straight to the probation department so they can get you started and everything you need. Okay.
Yes, ma'am.
All right. Good luck to you, sir. Here's that. Sorry. Good morning. Are you Hakee Thomas?
Yes.
And this is 25 DCCR 0843. Mr. Thomas is charged with aggravated robbery. What is the announcement?
Yes, in this situation, we've had several pieces of mitigating information that's come through from my client's family. I've been speaking with Ms. Mofino about this, and I think now we have a definite plan for us going forward with this case. We're not at the point of where we want to place on the trial docket or anything, so we just would like a little opportunity to see if we can get this resolved.
Okay. One normal reset.
Yes, Judge, I believe that Mr. Thomas's parents are in town for a meeting with Mr. Lewis. I have expressed things that I would be hopeful that they would discuss that may change some of our points of view, just in order to keep the dialogue open amongst all of us. There is also a co-defendant, Mr. Hartley, in this case, who has flatly rejected any offers, of the state. So I've asked Mr. Lewis to take that into account with respect to those discussions. So a reset, I think, would be timely with the court.
Sure. All right, I'll just do a normal reset. That way Mr. Lewis can get everything, visit with your family, get any information, get that to Ms. Malfino, have some discussions, and see where we are at that next court date.
Judge, I just want to mention, probably Ms. Malfino, I think it's a possibility that there is some more discovery that may be coming available. And so I may need a little time to, if
Sure.
it does, so I have time.
And that's the same issue we had last week with Mr. Wilkerson's client, Mr. Hartley, that we have reached out to Beaumont, have that. It's what I'm waiting on is from the out-of-county task force officers. I'll follow up again this week.
Okay, sounds good. Thank you very much. You can go back with the bailiff.
Thank you.
Good morning, sir. Are you Gregory Griffin?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does.
Mr. Griffin, in cause number 25 DCCR 1018, the state has elected to proceed on count 1 only. It alleges you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that's from July 21st of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes,
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yeah.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. I am also going to take judicial notice of the court's file. I think back last year, Mr. Griffin was evaluated for competency to stand trial by Dr. Hamza. And that evaluation at that time was that Mr. Griffin is competent to stand trial. Is there any other evidence with regard to competency?
No, that would be thanks, Judge.
Not from the state, Judge.
All right, then, Mr. Griffin, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
If you thought this case was intense, you haven't seen anything yet. Real courtroom moments like this happen every day, and we bring you the most shocking ones. Hit subscribe now, so you never miss the next verdict.